Welcome to This Week in Family Law, the go-to podcast for busy Australian family lawyers who want to stay updated without the overwhelm. My name is Jenna Downey and I am a family lawyer and managing director of Leap Family Law. My co-host today is Eleanor Buzewska. She's also a family lawyer here at Leap and legal content writer. How are you, Eleanor?
I'm well, thank you. Thank you for having me.
Thank you for coming on. Did you do anything nice for Valentine's Day on the weekend?
Sorry to laugh. I'm just thinking about how to answer that as a mum with two young kids. Absolutely not. I didn't do anything fun. But the kids now say Happy Valentine's Day, which is really sweet, as well as my husband. So it's nice overall, but it looks very different to how it may have looked years ago.
That is very sweet, and it's the reality of our lives at the moment, isn't it? I was very much the same, didn't do anything too special, but it's a nice day that we do recognise in our own way. And yeah, I think that's probably just got to be it for many years to come.
I think you're right about that.
Let's get into segment one. What's up, Eleanor?
So there's three pieces of news this week that I picked up on. The first was an article from the Law Institute of Victoria, which was released on Wednesday last week, the 11th of February. And it's an address from Federal Court Judge Justice Needham. This article was prepared in anticipation of her keynote address at the 2026 National Costs Law Conference, which is happening in Melbourne later this month on the 27th of February. And it's going to include an examination of specific AI tools that cost lawyers can use that may be helpful to them. And interestingly, Justice Needham suggested or recommended a use of multiple AI tools and said that lawyers really need to scrutinise that output and use it sensibly and ethically. However, it can cut a lot of the grunt work behind costs law.
It's such a positive update to hear, isn't it? Especially AI use being encouraged, albeit with some parameters in place for costs lawyers. But I feel like that is so different at the moment for family lawyers and the narrative that seems to be conveyed to solicitors at the moment.
I agree. I think it was interesting to me to read the article, especially this particular quote. So Justice Needham said, just as you would closely scrutinise work done by a junior lawyer, that is the attitude you need to take to AI work. And I think that's really progressive thinking. And I do agree with you, it's probably ahead of the market in terms of where family lawyers find themselves with AI use. At the start of the academic term for law students in 2026, at the University of Technology Sydney and at the University of Sydney, they will be able to have access to a global AI tool, Harvey. Harvey has already been rolled out to 35 universities globally in Europe, America, and in the UK. And Australia, through those two universities, will be the first provider. And the aim to make this AI tool available to law students is that it's perceived that these law students currently going through law school will really be the generation leading us into AI use.
It's such an interesting update to hear, isn't it? The fact that Australia seems to be behind the other countries in terms of introducing it into universities. But then also that I'm glad that they are, though, and they're obviously taking steps in the right direction. But then also the fact that you will have lawyers coming through who are very well versed in AI, and then currently in practice, you will have lawyers who are not versed at all in AI, and the disparity that might create between the junior and the senior profession, it'll just be quite different to what it is today.
It will be really interesting to sense what happens certainly in the next 5 to 10 years in practice because of that wide range of experience within a single firm. One thing that really stuck out to me when I was reading this article is it's just so different to my university days and our university days. So certainly AI was not around at all, and it was encouraged that you did, manual research work and heavily discouraged that you took from any resources. And I think that still continues to be the case. But the fact that there's this powerful technology underpinning learning, and that's considered to be credible and to help law students, is such a change in how university education for law students is being viewed.
Yeah, absolutely. I agree.
The third piece of news in this week is a Chief Justice of New South Wales address by the Honourable Andrew Bell AC. There was an opening of law term dinner on the 6th of February, and His Honour identified a pressing need for the state to, I quote, improve access to justice for all court users through advocating for increased investment in both physical and digital court infrastructure.
I also read somewhere that the president of the Law Society of New South Wales, Ronan McSweeney, is working closely with the Attorney General, the Department of Community and Justice and other stakeholders on this particular issue in 2026. So it'll be interesting to see how that progresses this year.
I agree. I think in particular rural and regional areas within New South Wales were identified of being in need of these added resources, and it's going to be a conversation we hear about throughout 2026.
They were great updates, Eleanor. Thank you. And that's what's up for this week. For Law in Motion this week, and off the back of Valentine's Day, Eleanor's going to discuss dates that might not necessarily be acknowledged as important dates within a family law matter, and how practitioners can actually deal with those dates for the benefit of themselves and also their clients.
Thank you, Jenna. It's a topic that I've only really had the benefit of thinking about with having moved out of private practice and had some time to reflect. Valentine's Day certainly had me thinking as well. And for family lawyers listening, your client potentially has just passed their first Valentine's Day alone. And this is one of those soft dates that we're often not trained to think about. And perhaps we don't do a good enough job taking into action when managing our clients and their expectations and emotions. In practice, I think every family lawyer is well versed and trained to take key dates down, and we know what they are. Date of cohabitation, date of marriage, date of separation, how long you need before you can file that divorce application, time limitation periods. But those are 5 or 6 dates you could wake up any family lawyer in the middle of the night and ask them about. They will be able to tell you. And I want us to talk about whether family lawyers can challenge themselves to think beyond those key dates about how their clients' instructions may be guided by triggering events. I think one of the things that I wish I did in practice is pay attention to a whole heap of sensitive information clients give beyond giving them advice on the spot. And what I mean by this is there would often be a client conference where I would get a wealth of knowledge, probably on a number of things I didn't consider to be legally relevant. So beyond giving that emotional support to the client and leaving them feeling like they have a safe space, I then wouldn't go back to my desk and diarise those dates. So a couple of examples of what we're talking about here. Valentine's Day is one of them, but other personal relevant information very much targeted towards that client. So things like perhaps when that client found out that the other partner was unfaithful, which led to the separation, the passing of the client's parent, attending events such as a first birthday celebrated alone with friends, or taking the child to their first birthday party for that child's friend alone. These are things that clients do open up about, but ultimately we need to do something with that information. And the reason I say that is because clients often call us in an emotionally heightened state. And I think it's very easy to say clients are emotional in family law. It's a broad brush we characterize all our clients with because it is true. But it's, I think, perhaps something we need to focus on in light of a diary. So what I'm suggesting is family lawyers should be building a triggering events diary or calendar for their client. And whenever that client calls and gives particularly emotional or perhaps you may think irrational instructions, you should be able to have access to that calendar and check whether there is a soft date or a non-critical date that you have missed that may be guiding them into giving you these instructions.
It is so valuable what you're saying because I regrettably in practice didn't really take note of those dates, but I appreciate how relevant they are in a matter. So I think this is really important for lawyers to be aware of. And have you had any experiences in practice of where having known the date might have been relevant or have helped the matter to go along a little bit more smoothly than what it did?
I think absolutely, and reflecting on some of the more anxious clients I worked with, I remembered a particular client who we worked together for a couple of years and there was an application listed on her birthday. In hindsight, that probably was nothing that we could help, but if I could file that application a couple of weeks later and avoided her birthday entirely, I would, because that event set us back, not only in her emotional state and her journey of grief after separation, but also it set our own relationship back because to some extent she would have felt that I didn't take that into consideration or didn't give enough weight to what was really important for her. So have to turn up to court on your birthday was something she's not going to forget as a life event.
I'm thinking back at my years in practice, and there's certainly an example that comes to my mind as well. And this could have certainly been avoided had I taken note of my client's birthday at the time. I remember I sent her a letter that I received from the other side on her birthday, and I received a rather nasty email in response saying, "Why did you have to send that to me today out of all days?" And I just genuinely didn't, I had her date of birth, but I genuinely didn't even think to look at that before sending my client correspondence.
But that's so, I think, relatable, and it's very much what happens in practice. I can hear the family lawyers, particularly listening to the podcast, thinking just how much do we have to worry about and think about. There are so many expectations to get things right, to deal with things sensitively. And there are hard skills and soft skills. And again, the work in practice is so draining and consuming. So to family lawyers listening and wondering, well, how can I avoid that very normal mistake? I think it's the start of the year, and that's why we're talking about this now. Building out a calendar. So sitting down with your client, or if you have an existing matter, looking back through the file and diarising key dates. I would suggest start at the end of the year. So we know there are some deadlines when court applications need to be filed for instance, school holiday time. And start from the end of the year and work your way backwards and acknowledge each term holiday, acknowledge each birthday, Mother's Day, Father's Day, which I'm going to put not as critical dates, but as dates that are often thought about. But then also, as we spoke, acknowledge the other softer, less known about dates and have that calendar up when you're speaking with your client.
And in terms of getting those softer dates from your client, it can just be done in a conversation, couldn't it? An open conversation. You're just asking, what do I need to know? How can I help you through this? And encourage them to tell you, well, what dates are meaningful and how it makes them feel around those dates as well.
It's, I think, so important to ask open-ended questions. It can feel actually quite awkward and hard, particularly for junior lawyers, to get on that level with their client and work out what's a sensitive way I can ask this and not offend my client, not have my client feeling upset. So open-ended questions and just sitting back and listening to what your client has to say is probably the best thing you can do. And you'll find that you'll get more information out of most clients that way as well. It's really about also building trust with your client. It's unrealistic, I think, to expect that your client will open up about soft, critical dates within the first 2, 3, or even 4 conferences or even more. Every client is different, and you just need to let that process run naturally at that client's pace.
Mm. And I hope this is helpful to hear as well if you are thinking about taking on the suggestions that Eleanor has made. Although I haven't been through a separation, I do have my own personal experience of loss. And I do find that the time period leading up to those specific dates is often harder than the actual date itself. So if you're going to do a calendar, perhaps mark the date, but then also in your mind think about that period of time leading up to that date as well, and whether it is a good time to perhaps get significant instructions from your client, or whether, if it isn't time sensitive, whether that could wait until after that date has occurred.
That's, I think, a really important point, Jenna, because when we think about, for example, let's say filing a court application or preparing a critical court document like an affidavit, we usually go back, don't we? And we diarise 4 weeks beforehand and 2 weeks beforehand. But what you're suggesting is you think about soft dates in that way as well. So if you know that this is the month of separation for the client, and leading up to separation, they had a particularly difficult 2 weeks. They may have moved out of the home and lived with their parents, or had something happen leading up to that period, including picking up belongings from a former matrimonial home, or any sorts of events that they remember as a difficult, blurry period for them. That also should be taken into account when looking at, for example, date of separation. So I agree with you. The lead up is just as important.
Thank you, Eleanor. It's been a very interesting topic for today, and something a little bit different than what we've done before. For your questions answered, we have received some further listener questions, which I'll ask Eleanor. First question is from Jess. I feel like I hear clients say best interests of the child all the time, but I'm not sure they actually mean the same thing the court means. What can I do as a junior lawyer to correct their thinking early?
Thank you, Jess, for the question. Absolutely, you're right. It usually never really is the same interpretation as the court. I found the same thing myself in practice when clients would probably, I think, over-apply the best interest principles. So I don't know if you've had the same experience, Jenna, but I'd have situations where a client would say, well, it's not in the child's best interest to have that in their lunchbox, or, you know, when they become familiar with that concept, they almost start overusing it. And I think having a conversation about best interests and having reference perhaps even to the act itself, and giving your client a copy of that early on and discussing with them what it means is the best way. Clients are not legally trained, and for them, every situation relevant to the child is going to be something they can apply best interest concepts to. So talking about this openly and referencing law in this particular instance, which I usually wouldn't recommend, but in this particular instance, I think is important.
For question 2, it's from Tracy. As the only one in my uni friend circle that chose to practice in family law, I sometimes feel like everyone is surprised by how family law actually works. Is there anything we should be doing differently as practitioners to change this?
Oh, that's a good question because I think I experienced the same thing amongst certainly friends from university, but also personal friends who are not in the legal sector. I think I've gotten comments of all types of natures, including it must just feel like you're having a gossip session with a friend. And I would say, no, that's not how it is. And I think there's certainly perhaps a lack of value for the type of service that family lawyers provide. It's hugely anchored in having technical skills and soft skills all at once, but there's also a need to appreciate and know about other practice areas as well. In terms of why this perception has been created, I think soap operas or legal shows and things like that have a little bit of blaming, and in general, I think in Australia, particularly family lawyers, there's a huge emphasis on early dispute resolution and alternate dispute resolution methods. So, in terms of correcting the narrative out there about what we do as family lawyers, I think it's just talking about those aspects more than, a court application or asset division or what could be, something that someone is advocating for that could be seen as controversial. Those things get spoken about a little bit, but also a lot of conversation is had about alternate dispute resolution and trying to settle things as well as possible for family law clients.
They're really good points that you make, and so helpful to be able to verbalise as well, because there's probably a lot of family lawyers who they're not sure when they went into the profession exactly what they signed up to in a way. So I think starting those conversations quite early on and giving exposure to what family lawyers actually do in day-to-day practice and what type of things that we're involved in is so useful.
Yes.
For question 3, it's from Joseph. How do you handle clients whose expectations are unrealistic but deeply entrenched? I have just finalised a parenting matter that was active for years, and every time I had a hard conversation with the client, I felt like I was losing them.
Same, Joseph. Although I haven't just finalised a parenting matter. Look, I think that's a really good question. It's really not an easy one to answer. It can feel like you're walking on the edge when you have hard conversations with clients, and hard conversations are happening all the time. My advice is to have a hard conversation as early as you can with your client, because it's going to get easier once the first hard happens. So other than that, I think we need to stay true to the advice that you give and appreciate that you may not get the reaction that you were hoping to get, but the client might still walk away fully respecting what you've told them and building trust within you as a practitioner, even though it can feel like you're walking on the ledge the entire time.
And that's our job, isn't it? It's not to have comfortable conversations. It's really to have whatever conversation needs to happen at a particular time, whether that's providing advice or just reality testing a scenario that they might be thinking is appropriate. There's a lot of hard conversations, I feel like, that need to happen with clients throughout the duration of a matter.
It absolutely does. And I think the earlier we acknowledge that and we just take it as part of the process, unfortunately, part of the role, then the better we will become at dealing with those awkward, uncomfortable, hard interactions.
Thank you, Eleanor, for answering those questions this week. And if any of our listeners have a question for next week, you can reach out to us by email, familylawpodcast@leap.com.au. You can also find us on Instagram and TikTok and message us through those platforms. We've loved being in your ears this week. Please rate and review us. It does help this podcast get in front of more people. And watch out for next week's episode. New episode drops every Monday.